Hi, I'm Monica Bay, Editor-in-Chief of Law Technology News. I'm here with Judge Andy Peck from the Southern District of New York City. So, your favorite topic right now, 502. Not everybody in the audience might know what some of us insiders live and breathe all the time. So, can you tell the audience a little bit about what it is and why it's so important?
Absolutely. Rule 502 was enacted and actually had to be enacted by Congress in 2008 with the goal both of reducing the risk of privilege waiver and coming up with a way to protect parties. In my view, the most important part of it is subpart D as in district. 502D says that if you get an order from the court under 502D, then regardless of how careful or careless you are in your privilege review, if a document is produced, and by document I of course include ESI, electronically stored information, and it was not intended to be a waiver, then it is not a waiver in that case or in any other case, even involving non-parties in subsequent federal and state litigation. To me, it's a no-brainer. It is your get-out-of-jail free card. I did not ever see in the old paper days when I was still in private practice or what I'm seeing now, there is no production that is perfect. Some privileged material is going to slip through, and you are much better off having the 502D order and being able to get that material back, no questions asked. The only other answer I've heard, and this was something that we did at the LegalTech keynote last year, we did and asked the audience with response technology, and it was really distressing. At LegalTech, the premier event in the e-discovery community, only about 10% of the audience in that huge ballroom said they were using a 502D order regularly. And in the follow-up question, which gave 4 choices as to why you're not using it, it was very scary that more than 50% of the audience checked the box responding, what the heck is Rule 502D? So hopefully we're making some progress and that this video will help as well.
Excellent. Any other thoughts in terms of the pending amendments to the federal rules that our audience should take a close look at?
One thing related is the amendment to the 26F conference and the Rule 16 order suggests that the parties talk about whether they want a 502D order. So hopefully those lawyers who are no longer trial lawyers but pretrial lawyers who focus on the federal rules of civil procedure and not the federal rule of evidence will now be caused to look and say, what is Rule 502 that's referred to here, and that will get it. Otherwise, there are many good things and some not as good in the proposed rule amendments, but I think that's probably beyond the scope of this short discussion. Well,
Magistrate Judge Andy Peck, I thank you so much for your time.
My pleasure.
I'm Monica Bay, and we will see you on the next edition of LTN Videos.